Morning from New York, I'm Chris Hayes. An Afghan soldier killed a U.S. service member and a civilian contractor overnight in Afghanistan. It's the latest in a spate of insider attacks in the country. And Arthur Sulzberger, former publisher and chairman of the New York Times, died last night. He took over the paper in 1963 and led it for 34 years. Joining me today, it's my great pleasure to have Jeffrey Toobin, author of the new book, The Oath, The Obama White House and the Supreme Court, also a senior legal analyst at an outfit called CNN, and a staff writer at The New Yorker magazine. Barbara Arnwine, president and executive director of the Lawyers Committee for Civil Rights Under the Law. Akhil Amar returning to the table. He's got a new book out. It's called America's Unwritten Constitution, The Precedents and Principles We Live By. He's also a professor of law at Yale Law School. And Nan Aaron returning to the table, president of the Alliance for Justice, which works to ensure a fair justice system for all Americans. It is wonderful to have you here. All right, this week we have two blockbuster political events on the calendar. The first presidential debate and the return of the Supreme Court to Washington. Tomorrow, the Supreme Court will hear arguments for the first time since their ruling on the Affordable Care Act, a stark and still extremely fresh reminder of the power of the court. Yet even as the court returns with a docket already packed with high-profile cases and several others likely to be heard, the Supreme Court is strangely almost entirely absent from the presidential campaign. This absence becomes even more alarming when one looks at the age of several of the justices. Anthony Kennedy is 76, Antonin Scalia is 76, Stephen Breyer is 74, and Ruth Bader Ginsburg, the fifth vote to uphold Roe, I will just note, the oldest justice, is 79 years old. Let's not forget that Ginsburg is, as I said, the fifth vote upholding the right to an abortion as decided in Roe v. Wade, a ruling Mitt Romney has said he would like reversed.
I hope to appoint justices to the Supreme Court that will follow the law and the Constitution, and it would be my preference that they reverse Roe v. Wade.
The stakes are incredibly high, not only for the Supreme Court's current term, but for the next 4 years and a generation beyond. It's very likely the next president of the United States will appoint several justices to the Supreme Court. That often is the most lasting legacy of an entire presidency. I find it strange, given the amount of coverage that Citizens United has gotten. I mean, Citizens United, if I've found when I go around, if I'm traveling or speaking to groups or reporting, particularly among progressive folks, center-left folks, citizens, everyone knows Citizens United. Everyone hates Citizens United. Everyone knows it was the court that gave us Citizens United. Everyone knows it was the court that upheld the signature domestic piece of legislation, not just for this president, but probably for Democrats of the last 30 or 40 years. And yet, the court is nowhere in the election so far. Jeff, you wrote about this yesterday. What is your take on why we're not hearing about the court on the campaign trail right now?
Because I've asked political professionals this question repeatedly over the years, and Democrats and Republicans by and large say the same thing. The professionals do. They say the people who really care about the Supreme Court are committed to their party anyway.
Right.
That the people who want Roe preserved are going to vote for the Democrats. The people who want Roe overturned are going to vote for the Republicans. And the swing voters to whom these campaigns are directed don't really care about the Supreme Court, even if they are pro-choice, even if in some abstract way they are against Citizens United. They are not motivated to vote based on Supreme Court appointments, so the candidates don't talk about it.
You know, it's interesting. We just completed a poll and found very different results. In fact, a wide majority of people do care about the court, are interested in the court. I think in part it's because of Citizens United. Perhaps they paid more attention around the decision on Obamacare. But not only is there greater interest in the court, but there's also growing concern about the corporate tilt of the Supreme Court and the fact that this is a Supreme Court that finds in case after case involving big corporations that they should retain power at the expense of everyday people. So, in fact, there is quite a lot of interest.
I actually think that's an interesting angle because I think the reason the court has loomed so large in our public and political life and the moments when it has been a big election issue is because of what we call social issues, right? It's because I think primarily because of Roe. I mean, frankly, it's because of Roe. And in some ways, the arguments, the conservative arguments, or even the liberal arguments against Roe as a kind of bit of constitutional jurisprudence is that by taking it out of the democratic process, it creates this sort of high-stakes battle over the court. Not an argument I agree with, but an argument that many people make. Mm-hmm. It's strange I think one of the reasons maybe the court's a little absent from this campaign is because of much of what the Roberts Court jurisprudence has been about, or the most important cases, particularly Citizens United, have not been in the social realm. They've been in the realm of the role of government. They've been in the realm of the relationship between how much standing plaintiffs can have against corporations, et cetera. Mm-hmm. And that doesn't, it's a harder point A to point B connection to make about how that affects your life.
Well, I would also say that, one of the other reasons why people have in the past paid attention to the court has been civil rights.
Right.
Because people care about their civil liberties, they care about their civil rights, and there are many issues going on in state legislatures and other places that impact these issues, and I think people do. I think one of the problems is that the court is so shrouded. It's hard to know what's going on in the court. What cases?
You've got to read Jeffrey's book.
Right.
I did my best.
I know, but it's the average person's just, it's not in the news, all the upcoming cases all the time, and it's just not a common where you don't see all these ads about the court. So I think as a consequence, people have not they just don't know what's up before the court. And then when a case is taken and it becomes, a big decision that affects people's lives, that's when people really get concerned and say, what is going on?
We're going to rectify that today, by the way. Strap in. This is going to be fun, actually. We're really going to get into it. Akil.
So here's one thing that also that is shrouded. Even if you know what the court decisions are, you don't know which justice will retire and how that might change which cases. Now, if we had, for example, judicial independence, but let's say 18 years rather than
term
tenure,
limits, you're saying,
which is what a lot of states do, a lot of countries around the world, then we'd know which seats would become open when. We wouldn't have to speculate awkwardly about his health or her family situation.
It is an awkward, grim business. We were even writing the scripts, and I was like, oh, this is sort of an awful...
But if we knew which seats were coming open and, on which issues that person was the swing justice, we could actually have a conversation.
The Supreme Court justices, when you say, oh, hi, how are you? It's a very freighted question. It's not a social pleasantry. But the point Akil made about term limits or mandatory retirement, I hear it all the time. I mean, I'm out talking about from everyone across the political spectrum that, the idea... remember, the Constitution was ratified written and ratified in the 18th century. Right. People died in their 50s in the 18th century. So the idea of routine 30-year terms, which is sort of where we're headed now. And look, one of the big issues at in the Obama White House when they were deciding should we nominate Diane Wood or Elena Kagan for the John Paul Stevens seat on the court is Diane Wood is 60, Elena Kagan was 50 at the time. That had a big impact.
If things keep going the way they're going, they're going to start scouting 3Ls because
that's right.
No written record and 80 years on the court.
And look, Clarence Thomas was nominated in his 40s,
and that's an arms race too.
Right. There's no end to that.
Though has put up candidates for the federal bench that are older than their counterparts were with the Bush and Reagan administration. So the fact of the matter is,
if the other guys are going young,
there's not as big a bench for elevation to courts of appeals or Supreme Court. And I would say, though, it is a guessing game. But I think there is the assumption that Ruth Bader Ginsburg will probably step down. She said she's going to step down. Most likely indicated that she might in the next 4 years. That will make a huge difference as to who the president is who's naming her replacement.
People step down in part depending on who's president.
Of course.
At the time their resignation to clone themselves. They like to live forever, but that's not given to them, so they prefer to clone themselves by stepping down on the watch of a like-minded president.
Chief Justice Rehnquist was, in his great sort of Wisconsin plain-spoken way, used to say, oh, yeah, we leave when we like the president.
Right.
I mean, and it's just very...
Scalia's just been doing a book tour, and he just had this funny thing where he's like, in classic Scalia kind of, combative way, someone said, would you wait until his release? He said, are you asking me, do I want someone to replace me who would get set to work undoing what I spent 25 years doing? No, I don't want to do that.
Well, and they all think that way. They don't express themselves as colorfully. And that's why, Ruth Ginsburg has said she wants to serve as long as Louis Brandeis, her idol, which would get her to sort of the middle of the next term. If Mitt Romney's the president, she'll pick a different idol.
And term limits or fixed term, like 18 years, is actually more independence from politics because then you're not timing your resignation in in political ways.
But also,
it's better.
But also, there's this real question about what's the life experience of these justices who are appointed to the court. What is their background? What are they bringing? What's their real life experience? What have they done besides, sat on a appeals court or, had a solicitor's background? What is the other? Have they done trial courts? Have they represented?
I want to talk about this.
These are real questions about what's the experience.
This gets us to the makeup of the court. It also gets us to whom we might see filling the court in the next term based on who wins. And I want to talk about that. I want to talk about what the fallout from the Affordable Care Act is going to look like, what the Roberts Court legacy will be going forward. All that after this break.
President.
All right, we're talking about the Supreme Court, which convenes tomorrow morning for the, Monday morning for the new term. Tomorrow morning. Today's Sunday. Losing myself here. And we're talking about what the consequences of the election are. I mean, we're waging a campaign right now. And one of the things that it has been absent from the campaign, despite the fact that if you look at the effect of, say, George W. Bush on the federal judiciary, it's been enormous, and it will last a long time because of the youthfulness of many of the nominees. If you look at what is happening in the Supreme Court, there's two academics who've put together something called the Martin Quinn score, which is a way of trying to come up with an empirical measure of the court's ideology. And we have a graphic here showing how it's moved over time. You see the court is very, very liberal during after the FDR sort of gets over the impasse, famously, of the court striking down new legislation. He threatens it with court packing. That's a political disaster, but he ends up getting to appoint a lot of justices, and you get a very liberal court during the New Deal. And then the famous court in the 1960s that gives us Miranda and a whole host of other pieces of a whole host of other decisions, a very liberal court. And then down, if you look at the bottom, 2010, it's basically the argument of the Martin Quinn score is we have the most conservative court essentially ever right now. And so people should keep that in mind as they think about this election and think about the possibility of opening up. Barbara, we left with you saying life experience matters on the court. And that segues nicely to who can we imagine being on the court if, say, Barack Obama is reelected and he has to replace a justice? And who would we imagine being on the court, nominated to the court, if Mitt Romney were to be elected?
Well, in terms of Obama, the great question that Democratic presidents have been asking certainly since Clinton is, can you get a non-judge on the court? I mean, Elena Kagan was not technically a judge, but her background as dean of Harvard Law School was sort of judge-like.
And a Solicitor General, temp justice.
And Solicitor General, right. We were discussing earlier, the court that decided Brown v. Board of Education, none of the justices, not one, had ever been a full-time judge before. When Alito replaced O'Connor, all 9 justices were former federal appeals court judges. Wow. That is a terrible lack of diversity. Sandra Day O'Connor, among her many virtues, was that she was a former politician. She knew what it was like to raise money. It's one thing to...
She was also a former state legislator.
Right.
And a lot of what comes before the court are statutes that are state statutes. And there's a lot of opining about what's going on in the state houses that doesn't necessarily match what's actually going on.
It's a great sense for the middle.
And Citizens United, is a case that talks about giving money to campaigns as if it's some First Amendment speech-driven, lovely process, whereas a politician may say to the colleagues, "Can I tell you what goes on? Why people actually give money to campaigns?"
Yeah. Well, I would think if this president is reelected, because there are so few Court of Appeals judges who are the right age, that he will have to look outside the judiciary, which I agree is a great thing. It's not only understanding how government works, but it's understanding people's problems, trying to fix their problems, redress their problems, hearing both sides and trying to mete out resolutions of problems. So I think I'd also like to see a justice who's been a civil rights lawyer, a public interest lawyer.
Deval Patrick, the governor of Massachusetts.
Beautiful.
Kamala Harris, the Attorney General of California.
Wait a second. Can you imagine a union-side labor, someone with a background in union-side labor law, being confirmed to the Supreme Court with the Senate that we have?
And we have to get away from this notion that we have to put only safe people up for these seats. Yes, if a president is willing to fight And we've seen presidents fight for their nominees. And because we have to be the heroes in this story also. But if we're able to gin up our constituencies, I think we can do it. Yes, I do. It will be a fight. A fight to end all fights. But you can't win a fight unless you start a fight. And I think putting on progressives is a possibility.
And that was one of the advantages of, the Sotomayor nomination, was that she had some life experiences working with a public interest organization on its board, having been a judge. I think that is one of the challenges here, is to put up some people who really are going to fight for the common man and woman. I also think that, there is this question that has been raised about the lack of an African American woman on the court. Never has been one. Right. Will this president actually look at that issue? Will there be, more diversity? We got, all kinds of issues around religion also, about more religious diversity on the court. There's all kinds of issues.
The Protestants are an endangered species.
It's kind of amazing.
It's an amazing fact.
No, there's 6 Catholics and 3 Jews, 0 Protestants, first time in history.
And if you look at the 4 people at the top of the vice presidential ticket,
only one Protestant, Barack Obama.
His father was a Muslim. You look at the head, mainstream, of course, Mormons are, and you look at Harry Reid and John Boehner, Mormon and Catholic, which the founders, I think, would have loved the idea that there aren't religious tests.
Well, I don't know if the founders would have loved it. They might have said they loved it.
Well, really genuinely open to talent of all sorts. But one thing on identity, it again matters who the vacancy is. For example, if Ruth Bader Ginsburg were to step down, there's probably more pressure to have a woman replacing that than if say Steve Breyer were to step down.
The other thing is if there's an unexpected if Mitt Romney is to win, because I think we're talking about as if Barack Obama, if Mitt Romney were to win and there's an unexpected vacancy from a justice who was appointed by a Democrat,
balance shift.
That would be the titanic fight of all time. I mean, if the fifth vote to uphold Roe is the vote that for some reason retires or leaves the court, right? And Mitt Romney is the president of the United States. That's the biggest fight ever in our lifetime in judicial confirmation. Hold on, I want you to tell us what that's going to look like after this break. All right, we're back. We're talking about the Supreme Court, which is going to begin its new term tomorrow. Jeffrey Toobin, I painted for you the picture of Mitt Romney being elected, a justice who is one of the 5 justices who would vote to uphold Roe should it come before the court again, having to leave the court for whatever reason, what that confirmation fight would look like.
Well, why that matters so much is that for basically a generation, the Supreme Court was dominated by moderate Republicans, whether it was Lewis Powell or Sandra Day O'Connor. Moderate Republicans have disappeared from the Supreme Court just like they've disappeared from the Congress. The last 3 justices to leave, Sandra Day O'Connor, David Souter, John Paul Stevens, all moderate Republicans, they are gone. They have either gone over to the Democrats. Souter and Stevens gave their seats to Obama, and the Republicans who've been appointed, John Roberts and Samuel Alito, reflect the modern Republican Party, and Mitt Romney, to be sure, would nominate someone like Brett Kavanaugh, young judge on the D.C. Circuit, or Paul Clement, former Solicitor General. Very conservative, not moderate Republicans, and that's why one seat would make such a difference.
And those 2 have very clear records, as did John Roberts and Sam Alito. We knew exactly who they were. We knew what they would do. And the Senate wasn't ready to really look at that record and make an
Can I ask a somewhat theoretical question, which is, okay, say we know there's 2 ways of thinking about this, okay? There should be some kind of deference to the executive in naming nominees that comport with the president's legal philosophy, ideology, and the Senate should basically be applying a standard of competence, right? Is this person qualified for the job? And then there's the kind of, hey, this is politics. Politics ain't beanbag, and a woman's right to choose is on the line. Right. This is a Hobbesian war of all against all. Do whatever it takes. Which is your belief system?
Well, I believe you've got to be competent, have an exemplary record, but we do need a candidate, Republican, Democratic, who will accept the progress that's been made in this country on behalf of women and people of color and workers, and be willing to advance that progress. That to me.
But no Republican nominee will have that. Will meet that standard. Then you fight them.
Then you fight them.
And here's why actually the Senate matters a lot on the ballot as well as the presidency.
Very good point.
Because it could be Republican in theory. It could be Democrat. And just even in the last few weeks, we've seen in places like Missouri and other places some interesting shifts. The Senate is not going to be filibuster-proof. It's not going to be 60-40 either way. It's going to be 52-48, or one way or the other.
Somewhere,
something like that. And filibuster reform also becomes a possible issue here.
We haven't seen a filibuster yet in recent years. There were Abe Fortas, I think,
that was in the 60s, but it wasn't a real filibuster.
Yeah, we haven't seen a filibuster in the current modern era of filibuster overuse against a Supreme Court judicial nominee, which is kind of remarkable given the stakes, given how often the filibuster is invoked, but that may change. Barbara.
Well, I think all bets are off. I think seriously.
No, I know. It would be a total war.
After you watch this last year of the lack of confirmations of judicial nominees from the Obama administration, if you look at the politics that have been played in the Senate, everything has changed. The whole civility, deference, all of that is out the window. It's just not the same. I think that the next Supreme Court nomination, we're going to see a whole level of animosity, a whole level of fight that is very new to us.
Let me quickly just put up this graphic, which is the percentage of confirmation of federal judicial nominees under Clinton, Bush, and the president. President George W. Bush got a very astoundingly high. President Obama still high, but 10 percentage points lower. And to me, it looks like a one-way ratchet, right? Things only move in the direction of obstruction. They don't move back.
Well, but also Republicans are more motivated on this issue than Democrats.
That is the problem.
Democrats, for whatever reason, have not gotten motivated on this issue. Plus, Obama deserves some responsibility here. Yes, only 78 have been confirmed, but he hasn't even filled all the seats.
Yes.
He has not nominated enough judges to fill the vacancies there. So the Republicans can say, well, how can you blame us? You haven't even nominated enough people.
And this asymmetry of motivation, I think, is so key and important. We saw it remember when the Democratic Senate was filibustering judicial nominees by President George W. Bush. The Republicans had this big event called Justice Sunday, in which they simulcast rallies around the country. That was when they threatened the nuclear option. They brought cots in, all of this stuff, because their interest group cares about this issue and exerts pressure more than, I think, with present company excluded, of course, you're doing God's work, Ann. But I think more than the progressive base does. And one of the reasons I just want people who are watching this, if you care about choice, and I don't know if you do, but if you care about choice, the fifth vote for Roe, upholding Roe, could very, very, very plausibly retire or not be on the court in the next term. And that, what we have seen in terms of abortion politics, with the sustained assault on choice at the state level from the House Republican caucus, that's not going anywhere.
But if you care about civil rights,
I would say it's abortion, but it's civil rights.
Right.
Workers' rights, environmental protection.
Why is it that Republicans are more motivated on this issue? Is it because Democrats are protecting the status quo on Roe and it's easier to attack than defend? Why is it?
Years and years ago, after Brown versus Board was decided, this was 1954. Remember, we saw people in the South with bumper stickers saying impeach Earl Warren. And from that moment on, there's been this growing crescendo of activism from the right. Roe versus Wade added a lot more soldiers to this army.
I think it also has.
And it's now become a huge fundraising tool for the Republican Party. It's a way for Republican candidates to nurture their base, rev up their base.
As a political reporter, let me say that I think a huge part of it has to do with the nature of the religious conservative base of the Republican Party and the degree they care about abortion, and also the Chamber of Commerce and the degree they care about whether plaintiffs get.
I just want to see one Democratic president say, I am the president who is devoted to the courts. That I want to see I'm going to make that.
Well, we don't see that because of the interest groups. We don't see that because they don't get the pressure to.
We didn't see that in Obama.
And because of what Tom Mann and Norm Ornstein have identified as asymmetric polarization more generally, the Republican Party having moved further to the right. And so they threaten filibuster reform, the nuclear option, when they have a majority in a way that Democrats haven't yet.
Excellent point. One counterexample, we all thought it was going to be
judicial nominations, younger than the Democrats. So there's asymmetry here.
A lot of people thought the Affordable Care Act was going to be the ultimate example of this kind of polarization, and it didn't turn out that way. Let's talk about that after this break. All right. The Affordable Care Act. Now, when we talk about the increasingly polarized atmosphere of the court, I thought, as everyone was looking, we were staring down the barrel of the ACA before the court. We had shows about it, and it seemed to me, look, this is kind of decision day, right? This is where it happens. Are we going to have a decision in which the 5 justices appointed by Republicans outvote the 4 justices reported by Democrats, starkly across partisan lines, on this partisan issue, on a very shaky, in my own lay opinion, constitutional reasoning, and the opinion of my esteemed friend Akhil Amar. And it didn't work out that way because of John Roberts. And this is what you say, Jeffrey Toobin, in your new book, The Oath, which is about John Roberts and Barack Obama. For Roberts personally and the conservative cause generally, his vote to uphold the Affordable Care Act, an opinion in the health care case were acts of strategic genius. Roberts, at a minimum, laid down a marker on the scope of the Commerce Clause. In addition, Roberts brought enormous political space for himself for future rulings. If people don't remember, Roberts found that the mandate of the Affordable Care Act was constitutional under the taxing authority of the United States Congress, as found in the Constitution, that as an exercise of the Commerce Clause power of the Constitution, it exceeded the constitutional limits. So he doffed his cap to the argument that Randy Barnett, who'd been on the show with Akhil before, had made. This is an ominous statement to me. This gets me scared, right? Because then I think, well, he bought this down payment on credibility that he's now going to use for the next 20 years to gut whatever he wants and be like, remember the Affordable Care Act?
Well, and I think that's right. Look, I think this case was the third in a trilogy. Bush v. Gore, 2000, Citizens United, 2010, Obamacare, 2012. 5 Republicans, striking at the heart of what the Democrats wanted. Roberts pulled back from that. And I think he cares about the institutional reputation of the court, but at the same time, he did not suddenly discover his inner moderate. Right. He is a very conservative judge. When we start talking about the civil rights cases this term, when we start talking about abortion, all the corporate agenda cases that have come before the court and will come before the court, this is a very conservative justice. And now he is bulletproof for accusations of political hackdom.
I agree with that, and it connects with what Nan and others have said before. Jeff, you have a lovely line in your spectacular book, which everyone should read, that he is able to play, John Roberts, the long game. And part of the reason that he is he's appointed as Chief Justice at a very young age, and so he can be setting things up now. And what he's setting up is his personal credibility and the credibility of his branch, his institution, as not as completely and partisan on every issue as maybe the House and the Senate. It doesn't always vote 5-4 on pure party lines.
Can I make one just quick point about the Affordable Care Act, which is not my own point. It was made to me by a very, very smart legal mind. But the reasoning on... this person said to me, if you're figuring out whether something is constitutional or not, all you need to do is find the reason it's constitutional and throw up your hands and say, done. We've done it, so we found another taxing authority. Yeah. You don't then go out after you've already found that it crosses the threshold of constitutionality and say, well, also this other thing, just FYI, not constitutional under Commerce Clause. It's a very bizarre thing to do.
That opinion was so strange in so many respects. I mean, you had a jointly signed dissenting opinion by the four other Republicans on the court. You had this very strange, sort of, as you point out, this was like John Roberts' opinion about the Commerce Clause, totally irrelevant.
It's like his op-ed appended to the constitutional reason.
Relevant to the case.
The other smart thing about this opinion is that it really removed one of the Supreme Court as an issue during this campaign.
That's right.
We'd be talking a lot more about that.
That's a very smart point.
But none of us is going to give John Roberts a free ride now. None of us.
You professionally can't, man.
That language on the Commerce Clause. I mean, the Commerce Clause sounds like the Commerce Clause, but it's really the foundation for progressive reform in this country ever since the New Deal. So, no, he doesn't have a free pass. And as Barbara and others will say, there are a host of critically important issues coming up.
Are you worried, Barbara, about I think there are sort of split opinions about what the Commerce Clause holding, if you could even call it a holding, which is a little confusing about whether it constitutes a holding, what the Commerce Clause holding means for the sort of modern progressive interventionist state going.
Well, everyone in our office, when we read it, were very concerned about the views that he expressed. But this is, it's somewhat the Roberts that people who know him talk about, the one who likes to every once in a while shock and surprise people by taking a position that's inconsistent with his general outlook, because he did it in the Arizona case. He did it in the Arizona case. He did it in this case. I mean, the question is, will that Roberts surface more? Is he really there?
Well, now what I'm hearing from Jeff is forget about it.
I think this ticket was good for this train only.
And here is one thing about his mentor. Chief Justice Rehnquist, for whom we clerked when he was Justice Rehnquist, I don't think there was a single case in Chief Justice Rehnquist and previously Justice Rehnquist's tenure in which he was the fifth vote for any liberal outcome in an important case. And that's his mentor.
That's big.
Ann Aaron of the Alliance for Justice, thank you so much for joining us this morning.
Chris.
Great to have you at the table. All right, we're now reading in the potentially landmark cases. Huge issues. Will the Voting Rights Act survive? Will affirmative action or racial considerations in public academia anywhere survive? All of that is coming up next. Asking my guests how you pronounce her name right before coming back. Super professional move. Joining us now is Elise Boddy, Director of Litigation at the NAACP Legal Defense Fund. Great to have you here.
Thank you for having me.
All right. Let's talk about the future of affirmative action in America, which is not just before the court, but is on the docket, certainly. Arguments are scheduled. It's probably the first big blockbuster case I think the court will hear. The court's going to hear an interesting case called Kiobel tomorrow, which is about corporate personhood and this strange statute called the Alien Tort Act. We've covered that before, but that's a little in the legal weeds. So we're going to go to Fisher because basically what appears to be on the table is whether the court will allow any kind of consideration of race as a factor in admission to higher education to promote diversity in the sense of affirmative action. Chief Justice John Roberts has shown through a variety of writings to be incredibly hostile to this notion. And there's this famous statement of his from a case which was called Parents Involved, in which the court struck down a mechanism for integrating public schools that was quite popular. The parents were behind it. It was not busing. It still was struck down. And Chief Justice John Roberts, his famous line is, "The way to stop discrimination on the basis of race is to stop discriminating on the basis of race," which is kind of a freshman undergraduate level tautology, I think. But what is at issue in Fisher? What are Elena, maybe Lisa, you want to lay out for us what's at issue here?
Sure. So the question that the court is being asked to decide is whether the limited consideration of race in undergraduate admissions at the University of Texas is constitutional. And it's important here to have some sense of what the trajectory of the Supreme Court's jurisprudence has been in this area. This case is about revisiting a previous decision by the Supreme Court, 2003 case involving the University of Michigan, in which the court resoundingly upheld the use of race in admissions, provided that it's one of many different factors and it's used to promote the educational benefits of diversity. The Texas case is a little different because it comes on the heels of a law that was passed by the state of Texas back in 1997 following a decision by the local court of appeals that banned the use of race in admissions. The state legislature essentially said if you graduate in the top 10% of your class, you're automatically admitted to the flagship institution. That worked, as it turned out, because
American schools are super segregated, as are Texas schools. So you could say top 10%. It's this amazing runaround.
Exactly. And so the question here, so we have the 10% law, which admits the overwhelming majority of students to the University of Texas. And the question is whether this separate admissions policy that considers race in an individualized way, whether whether that's constitutional.
So we have the facts here are a little complicated because there's this kind of two-tiered admission thing, right? If you're not in the 10%, you obviously can still apply, you can still get in, and they use race as a factor in considering. The court had found that it's a compelling state interest, right? That the government has a compelling state interest of promoting diversity,
right?
And in the means of doing that is taking race into consideration to ensure there is a diverse classroom. The plaintiff in the case, who is a white student who did not gain admission, and there's a line of cases, right, of white students who don't gain admission, starting with Alan Bakke back in the 70s,
exactly. Right.
Suing and saying I'm being discriminated against. The big question, though, here is there's a lot of feeling, I think, that they're going to just use this as an opportunity to kind of do the full Citizens United, which is just come down with a decision saying you cannot use race at all.
Well, certainly, Justice Scalia, Justice Thomas are on record saying that is what the Constitution requires. Again, what's so interesting here is the political context. The establishment in this country, Fortune 500 companies, are all behind diversity. The very celebrated group of military veterans, including Norman Schwarzkopf and Colin Powell, are saying we need affirmative action in the service academies. So, all the big Fortune 500 companies are saying, look, we are competing in a global marketplace. We cannot have our flagship universities all white. We draw our employees from these places. But that's from the people who are filing briefs in this case. But the conservative movement in this country has done a really good job in communicating the idea that any use of race, as John Roberts has said, is discrimination. And that's a powerful argument.
Barbara, I want to hear your thoughts on it a bit. First, I want to take a quick break. More on that when we come back. We're discussing the Supreme Court's docket and whether the Supreme Court is going to essentially, I don't think it's too dramatic to say, strike down affirmative action in arguments the court will hear next Wednesday. Barbara, this is a case that you've spent some time thinking and working on. What's your feeling about where this is headed?
Well, first of all, people got to remember that this is a case that's coming on cert from the Fifth Circuit of all circuits. This is not a, quote, liberal circuit. This is a very conservative circuit court that upheld this plan. If there's ever a plan that the court should like, it's this plan.
Let's be clear. The Texas state legislature voted for the plan, and the very conservative appellate court that is that region of the country in the South upheld it, and now it's before the court.
And when it was adopted, 79% of all classes at the University of Texas, Austin, had either no African Americans in the class or had one. So it was really a question about academic diversity, academic expression. It's also very important to look at this plan. This plan has no set-asides, no added points. It has individual consideration. Race is just one of several factors. Languages that are spoken at your house. Is your family a single-parent household? They consider things like your awards. They consider your musical ability.
And these are all lined up as equal considerations.
Absolutely. And in fact, there's a great argument that even the plaintiff in this case, that even if there was no race at all used, she still probably wouldn't have been admitted. That's important.
Yeah, and let's be clear. I mean, what's important to understand here is that race is not an automatic consideration for any individual. In fact, race can count for anyone. If you're a white student attending a majority Latino high school, for example, and you have certain extracurricular activities, that might be a special circumstance that would warrant additional consideration. Same with Asian Americans. So it's very important to keep in mind that this is a flexible consideration of race, which really matters in this calculus. The other, I think, important point to recognize here, and folks like to focus on Chief Justice Roberts, but really Justice Kennedy is where the game is here. And I think, Kennedy himself has acknowledged in his a prior decision regarding K-12 integration that diversity matters, and he favors diversity. He recognizes that as a country we're still struggling with persistent segregation. Colleges and universities are uniquely situated to address this very problem, right? We have persistent segregation at the K-12 level.
Exactly.
Where else are we going to learn to live and work together but for in higher education?
And we're talking possibly not just about our great flagship public institutions, but also private institutions. They're not governed directly by the Constitution, but there's case law that says if the state can't do it under the Constitution, private schools can't do it under anti-discrimination law. And then we're talking about the possible prohibition of affirmative action at Harvard, Yale, at all the private institutions of the country alongside the public ones, that would be dramatically different than the status quo.
But I think it would be a huge mistake. When you really, I mean, seriously, when you consider that our nation is fighting for its economic advantage, that is fighting to be competitive, if you take out affirmative action and you give this, we just go back and we resegregate all of our higher educational institutions, what a disaster that is for the United States of America. But when you consider what our demographics are right now.
And just to go back to the plan itself, so the technical legal question that the court is going to entertain is whether there was a need to consider race in an individualized way on top of the 10% plan. And going back to Justice Kennedy, I think what's important to understand here is that the individualized consideration of race in the supplemental policy it appreciates that racial minorities are not fungible, right? That black students who attend segregated high schools have a different experience perhaps from black students who attend integrated high schools. And I think Kennedy will like that because he has said in his previous cases that he rejects this notion that everyone should be, treated alike, that black students and Latino students should be lumped together. And so this is consistent with that idea.
Let me also say this is not a particularly legal point, but I'm always amazed by the idea of applying to a school and not getting in and deciding you're going to sue as like a plaintiff. I mean, I don't want to cast aspersions on this individual, but let me, as a legal matter, this is a court that has shown itself has set a higher and higher bar for standing, right? Can you bring a suit before this court? This has been one of the jurisprudential themes of this court. And in this case, it's just unclear as the counterfactual whether she would have been admitted with or without the plan, and yet that seems to be totally waved away.
She's also, as I understand it, already graduated from college
at
this point. Yeah. Why is this case not
another huge case that could have profound implications, probably would be the biggest, that might make the ACA actually look small, I would even say, is whether the Voting Rights Act can survive the Roberts Court. Let's talk about that right after this break.